Hi, and welcome everyone. We're here at Florida Closing and Escrow, and we're the only title company in Sunny Isles. We're multilingual, mobile, and we assist you from contract to closing. We have a 5-star rating, and also John, the owner, John Iowanu, was voted top 50 real estate attorneys in America. Yay! So today's topic is about the buyer broker agreement, and then we will go into the NAR form updates. And if you need the forms, you can contact me. They're also on Form Simplicity, but I could be reached at 786-457-6832. And I can also assist you with novel real estate marketing tools, digital and targeted AI campaigns, BOW live stream opens, and more. So welcome everyone, and welcome John.
Hi. Hi, everyone here. Hi, everyone here. Today, we're going to be talking about the new forms that NAR proposed and the Florida Association of Realtors prepared. So everyone have this form called the Exclusive Buyer Brokerage Agreement? Yeah. Okay. Everyone on the internet, if you need a form, Cindy has it. Otherwise, it's in Form Simplicity. You'll be able to find it there. All the forms are updated. So why are we talking about this form today? Well, basically the antitrust lawsuit that went against NAR, everyone remember that, where plaintiffs won $1.78 billion lawsuit against NAR and several other large brokerages, was settled for 418 million to be paid over 4 years. And also, in addition to the money settlement, NAR agreed to 2 additional rule changes. The first rule change was offers of compensation will no longer be on the MLS. We're all aware of that, right? Beginning August 17, this is when all this is taking effect, offers of compensation will not be a field on the MLS, right? We all know that. So because of that rule, last week we talked about the compensation agreement that we're going to need between brokerages that needs to be signed. Otherwise, if you don't get that signed, you're not going to get paid at time of closing. So the compensation agreement is what needs to be signed prior to closing. But part 2 of the settlement is that the buyer needs to sign a written representation agreement with the buyer's broker. That was rule number 2 change. And so what's that? So there are 3 forms that NAR has proposed you can use. The 3 forms are the pre-touring, the property pre-touring agreement, which is basically, you probably have seen it, property pre-touring agreement. It's a very small 1-page document that just says, I'm going to hire you to take me around and show me properties. The second agreement is the showing agreements. And that agreement basically says, I'm hiring you to show me this property. And if I buy this property that you're showing me, I'm going to pay, or you'll be entitled to the commission. The third agreement, which is the agreement we're going to talk about today, which is a really good agreement for you all, is the exclusive buyer broker agreement. And obviously, with the name of the title of that document, exclusive buyer brokerage, they are using you exclusively. So as opposed to the showing agreement that says, I'm just going to hire you for this property and I can hire other realtors for other properties, the exclusive buyer brokerage agreement is similar to the exclusive listing agreement, where they're hiring you only. Consider it, one of the presentations given by NAR was, consider it a marriage. You guys are kind of married with the exclusive buyer broker agreement. You're committed to each other and the buyer can't go anywhere else. Obviously, between the 3 choices, you have to sign one of them with the buyer. Beginning August 17th, you must. If you don't, you'll be there'll be fines that can be imposed, penalties, and even suspension. NAR mentioned, and actually the Florida Association of Realtors mentioned, they're going to be taking this seriously because it's not fair if some realtors are being forced to use these forms and some aren't. So they're going to take enforcement very seriously. So you have to use one of these forms. And obviously the best form to use is this exclusive buyer brokerage agreement because there's a lot of protections in here for you as a buyer broker. And let's go through those. Okay, first, so top of the page, one of the main changes is the buyer is now the consumer. They're not the client, they're not anyone else, they're the consumer. That's the name of the buyer. And it's granting broker, you'll see on the first paragraph, exclusive right to work and assist the consumer in locating and buying a property. Okay.
Thank you.
Uh-huh.
Thank you so much.
The next paragraph, paragraph 2, this is the term. So obviously it's blank, so it's negotiable. Whatever you think you can get the buyer to agree to, obviously longer the better.
Yeah.
Obviously shorter, not as good for you, but you can work with the buyer with that. Maybe a week, no, I would do it. Maybe a month, a couple months, 3 months, 6 months. Like I said, the longer you, it can.
Yeah.
If the buyer agrees to it, sure. That's the point. You're going to, the buyer has to sign this agreement. So you can maybe start with a year, and when you're speaking to them, they say, well, isn't a year a little bit too long? Maybe 6 months, and you can kind of negotiate that. The good news is, in the last sentence of this paragraph states that this agreement will continue in effect until the transaction has closed or otherwise terminated. So, as long as the buyer enters into a purchase agreement within this time period, you do not need to extend the term until the end of the closing date. The term automatically extends to the end of the closing. So even if the closing is going to be a year from now, you're protected because the contract was signed during this term period. Okay?
But here they say location, has to be a specific location because why did I show different properties?
So, right, so paragraph 3, it says type of property and location. So they told us that this can be whatever you want it to be. Condo, single family home, location can be zip code, can be city, can be county, can be the state of Florida, but if you have a buyer that's coming down here and that says, hey, I want to find something in Miami, you don't have to put state of Florida, you can put Miami-Dade County. If they're looking around here, since we're close to Broward, you might want to put Broward and Miami-Dade County.
Protect ourselves, they want to be, we border Miami-Dade and the Broward. Can we
Right.
just make it easy, Florida?
You can. You can.
And just cover everything,
It's,
because today they're looking at Sunny Isles, tomorrow is.
I would put South Florida if you want to be
So,
a little bit more specific. But they don't say there's any limitation on location. So, Florida, South Florida, they might tell you, the buyer, if you put Florida, they're gonna say, no, I want you to change that to a little bit more specific, in case they do maybe change their mind, they move out of the county and they move up north. They're not gonna expect you to travel with them to find them property in North Florida, so.
South Florida.
South Florida might be a good idea. Okay, paragraph 4, these are your obligations as a broker or broker assistant or agent. And these are pretty standard for transaction brokers. You're gonna use your professional knowledge and skill, and you're gonna do viewing suitable properties and things like that. 4B says that the consumer is also aware that you might have other consumers that you're taking around and showing property, and the consumer's okay with that. So you can represent more than one buyer at a time. 4C basically states you're not going to discriminate.
But only one buyer will sign this.
Yes. So for each buyer, you have a new one of these. Uh-huh.
Can we start now?
Yes, absolutely. I would recommend starting now because beginning August 17th, you're gonna have to send this out to all your buyers. So instead of confusing them now, for each property for each buyer, the property can be location we were talking about, South Florida. So no, not for each property, but for each buyer.
Which buyer? So if I'm talking
Yes.
to someone,
Now,
I did told her that's new, but I probably did something. I said, it's coming from August 17. So if you don't buy before August 17, you'll be responsible to sign the form with me and pay to my broker.
yes, that's okay. If it's not closing before August 17th,
Closing, not getting into the contract.
right, closing before August 17th. Okay, so try and get this form. If not, what NAR and FAR told us was if you don't have one signed, they're going to require this to be signed. If you do have one signed and you're using an old form, which doesn't really matter now because there's no old forms, they were going to provide a disclosure. So if you don't get it now, you will need to get it on August 17th if the closing is going to be after. So it's a, I would definitely recommend now because let's say on August 17th, you say, hey, buyer, you have to sign this. And buyer says, I'm not signing it.
No.
Then what do you do?
And
Then you're
this
in
is
trouble.
only for buying or lease also?
It's also for leasing, and we'll get to that on the next page. Good question. You guys are good. You're smart. You're picking up on things. So going back to 4D, this is actually good protection for you guys as well. It's 4D. Broker does not warrant or guarantee products or services provided by any third party. So let's say you recommend an inspector, the inspector misses something. This protects you and says, hey, I'm not responsible for what the inspector did. So this form, although cumbersome and adds a little bit more work to what you guys have to do, actually is good for you as realtors because there's some protections in here. Not to mention that they can't be using 5 realtors at the same time, and they're not just kind of taking you around for a ride and not expecting to use you when they buy a property.
So let's say the buyer is thinking that he's smart, and he signed with me and with her in the same month, and buys with him.
Yeah.
Yeah.
I think so.
Good question. The answer is this is a legally binding contract. He will have to pay
All of
3
us.
of you.
Oh,
Don't do that.
That's.
So when you explain this to a buyer, say, hey, you have to sign this number 1, because if you don't sign it with me, you have to sign it with her, so you have to sign it. But also you can tell them, be very careful, you cannot sign more than one of these because you have to pay all 3. Yeah.
Okay, let's say this happened, accidentally or intentionally, not intentionally. Somebody says, I'm a lawyer, don't tell me what to do, I know the loop, I'm gonna do whatever I want, he buys it. So now, let's say the other 2 people going after him,
Mm-hmm.
and he has no liquid money. So what do? We put lien against his home and wait forever?
No, you won't be able to get a lien. You'll get a judgment against him, a paper judgment, and it'll say he owes you $10,000. Then you have to somehow collect. And the collection part is what every lawyer has difficulty with when people are insolvent. What can I do? Garnish wages. There's a couple of things you can do. But just tell them at the beginning that you'll be responsible to pay. You cannot put a lien on the property,
No,
but
what thing would they not pay?
you can take them first to mediation. And if mediation doesn't work, then you can sue them. And if you don't want to sue them, there's a section in here we're going to talk about arbitration.
So we pay for attorney's fee or we can put it on them?
Attorney's fees will be paid by the loser. So if you sue them and they lose,
I'm gonna tell them the whole thing from the beginning.
yeah.
It's clear.
Okay, so then we go to paragraph 5. This is actually, 5A is very good for you guys as well. Conducting all this is what the consumer's obligations are. And what we're gonna look at is sentence number 2, where it starts, if consumer contacts or is contacted by an owner or a real estate licensee who is working with the owner or views a property unaccompanied by broker, consumer will, at first opportunity, advise the owner or a real estate agent that consumer is working with and represented exclusively by broker. So now there's no the buyer going directly to the seller and trying to work a deal, or if the seller contacts buyer and says, hey, you want to work a side deal, buyer has to tell the seller or seller's agent, I have an agent or I have a broker and you need to contact them. Obviously, if they don't do that and they try and do a side deal, again, this is a legally binding contract. You can sue the buyer for that commission. So that's why this form is actually really good. There's a lot of protections in here for you guys. 5B, that's just providing information to title companies and things like that. C, being available for showings. D is also very good for you guys. Again, indemnifying and holding broker harmless from and against all losses, damages, costs, and expenses of any kind, including attorney's fees. So there's indemnity language in this agreement that protects you and your broker. 5E,
Shut
I
it
did
off.
put, I don't know what's happening.
there's a button on the side that
I
goes to,
did, it's all the way down,
oh, okay,
I promise.
that's all right.
Just put this on.
Indemnifying, okay, 5E, not asking,
That's on iPhone. It's on the-
oh, then on iPhone, okay, all right,
Sorry.
no problem. Okay, so then we're done with the first page, so the consumer and the broker slash agent. So you can sign it as an agent for your broker. If your broker is okay with that, a lot of brokers are saying, yeah, you can sign this. Some brokers might want to sign it and don't give you the authority to sign. Just check with your broker to make sure that they're okay with you.
So when it's walking name or my name?
Broker name,
Walking,
brokerage,
not my name.
correct, correct. Because you're an agent for the broker, so.
You can put the broker and your name at the same time.
So what you can do, another realtor asked is, can I put the broker's name slash my name, so when I turn it in to the office, they know, they see my name at the top. So you can put slash your name, yes, if you wanted to.
Which line?
At the very top, paragraph 1, yeah.
Oh, the first one.
Yeah.
Yes, I don't.
Mhm. Okay, page 2, we're going to paragraph 6, retainer. If you can get a buyer to give you a non-refundable retainer, go for it. My understanding is a little bit difficult. Well,
Like deposit.
not even deposit. This is here's money I'm gonna give you. You're not gonna give it back to me. Money for you to take me around and show me properties.
We didn't have that before, this is really good.
I thought it was rare, but my last session I did, there was a realtor that says she gets it all the time and she doesn't do any work without it.
She said, I said, tell me how you tell to your client, because I'm shaking her to ask for money. She says, I told them right away, you give me 200 or 300, depends who, 250, and I have it on a contract that she charged them. And then she says, Tailana, if it's not gonna work with this, I'm gonna tell them, I'm sorry, I'm not gonna work with you,
Mhm.
because I spent so much time with them and they cannot make up your mind. And I said, and they paid you? She says, yes. I said, how? She said, they tell me.
Yeah, so it's possible to get it done. If you can get it done, great. It's another negotiating tactic that you have to do when you sell yourself. You're gonna have to possibly sell this as an option. But you're gonna have to tell them it's non-refundable. So if they give you $500, they're not gonna get it back if they don't close. And also, it's not gonna reduce your commission. So let's say your commission is $10,000. You're gonna get that full 10,000. You're not gonna get 10,000 minus 500. So
Question?
it's in addition to, yes.
I'll put it down.
Mhm.
So we practiced before asking, Claudia, we practiced before asking $500 upfront. We didn't, we said, I said it retainer, but I can return it to you at the closing. So you kind of give it to me deposit, showing me that you are serious buyer. And that will allow me to be, to feel confident about you and proceed. But if they say, no, what are you talking about? I'm not gonna pay, especially now, I have to pay you my commission. Can we practice it and say, look, I will give it back to you, this $500 at the closing?
Yes, this is not part of the settlement agreement, so it is negotiable. So what you could probably do is put in the additional terms that Yeah, on paragraph 13, you can put whatever additional agreement, if so-and-so, or
And
after a
if they
certain
don't
amount.
buy legally, if they decided don't buy or their mortgage didn't go through, there's no deal, there's no sell. What happens with this $500? Do I have to return or I can collect?
According to paragraph 6, you do not have to return it because it's non-refundable. On paragraph 6. Right.
Telegram the phone.
What were you asking about? A refundable deposit?
The note that she will give it the
You're
money
not gonna
back.
have everybody who's gonna say, I'm not gonna give you non-refundable 500, right? Or
Okay.
everybody's gonna say, okay, take it. Some people may say,
Well, if you
no.
say it's a refundable deposit instead of non-refundable, then yes, it's refundable if it doesn't
That we
close.
need to buy. Okay.
Unless you put terms, it's refundable after the first week. It's not, half of it's not refundable after 2 weeks of driving you around and fully non-refundable after 3 weeks. You can start working with that. That part's negotiable.
Yes, okay.
So we go to paragraph 7, compensation. So this is where the percentages go. Last sentence of paragraph 7 is very important. Compensation received by broker, if any, from an owner or owner's broker for services rendered to consumer will reduce any amount owed by consumer per this paragraph. So if you put 3% here and the seller's offering 3%, you get 3% from the seller. You don't have to get it from the buyer. The buyer doesn't pay. So basically you say, I'm gonna put 3% here. If the seller gives 3%, you don't owe me any money. The issue that is that you're gonna have to sell yourselves is if the seller's offering 2% or 1% and you have 3% here, buyer's responsible for the difference. Here's the problem though, and I don't necessarily want to call it a problem, but let's go to the next page, paragraph 14. The second highlighted and bolded and underlined sentence. Broker may not receive compensation from any source that exceeds the amount or rate agreed to with consumer. So if you're in an agreement with the buyer and the buyer says, look, I'll sign this, but I'm not gonna pay you anything and I want you to put 0% here. You can't put 0%. If you put 0% here and seller's offering 3%, you're getting 0%. So you're gonna have to tell, I guess an idea to the client is, we have to put 3%. And then you're gonna have to decide on your own, do you wanna tell them if the seller's offering 2.5, that I'll reduce it to 2.5 or 2, or do you wanna stay with the fact that buyer will pay the difference? That's up to you, however you wanna sell yourself. If you do tell them that if seller's offering 2.5%, I will reduce my 2.5%, there is an addendum to this form that will say you're reducing the commission to 2.5%. So it's very, very important that at least now you put 3%. You have to tell the client.
Closer to the closing when we have a CD or hard.
No, so going back to that first rule, the compensation agreement is what you're gonna sign with the broker. So that played out where you,
If I'm not the listing agent, I'm bringing the buyer.
uh-huh,
The listing agent knows how much they signed for, 5% or 6%.
but you're gonna find that out at the very beginning because you had them sign a compensation agreement. Remember the form we did last week? The compensation agreement between brokers. So you as an agent, you're gonna call the seller's agent, hi, I represent a buyer interested in unit 306, is it available? Seller's agent's gonna say yes, then you're gonna say, what are the showing instructions? They're gonna tell you, and then you're gonna say, what's the offer of compensation? And then they're gonna say 3%. And then you have to send them that compensation agreement we talked about. And Marguerite, you weren't here last week, so I have a form I can give you on the way out. You guys better attend my classes.
We also have it live. We have it recorded on bowlive.net if you need it. And also, if you want to contact me for 90 reasons why you should work with a real estate
Can you promise me?
buyer, for buyers, I will send it to you, and also 13 reasons why the seller agent should work with the real estate agent who represents buyers. I'm happy to send it to you.
Okay,
Is this also for the lease? or not?
so
We have
good
to-
question. So that's where we come up to 7A. First, for the purchase, if your broker charges a broker processing fee, you have to use the second set of spaces. So right now, A says 7A, purchase or exchange. If there's a flat rate that you agreed to with the buyer, you would put a dollar amount there, or 3%. Then it says select only one. Then it says or a dollar amount or percentage plus. And then that's where you would put the broker processing fee there. So if your broker does charge a broker processing fee, you only put 3% on the second percentage. So it looks like this. So if you don't charge if your broker doesn't charge a broker processing fee, you just put 3% on the first percentage line. If they do, you put it on the second percentage, and then the next line, you would put your $4.99 broker processing. Does that kind of make sense? And if you want, here, give me a pen, Isaac, and I'll show. So 3% and $4.99. So if there is a broker processing fee, it'll look like this. Just that only. You wouldn't put 3 twice. You'd only put 3 once. You see that, Dylan? So just there and just there.
I'm not in here.
And nothing on the first one. If your broker charges a broker processing fee. If they don't, then you just use that first
Okay.
percentage and just put 3 there and nothing else. Make sense? Kind
What
of?
they charge? All brokers charge.
Yeah.
Yeah.
We charge.
Oh,
I charge my client.
yeah. Why not?
What about half month?
Okay, so then we go to 4B, leases. If you do have a buyer that says, well, I'm looking to buy or lease, I'm not sure yet, then you would put 5% there, right? That's the standard half month's rent. And you'd fill out that section for B. If they do say they might lease, then it's also important to check paragraph 7C, which is the option. Maybe they're going to enter into a lease with option to buy. Then you would put 3% there under 7C. But if you have a buyer that says, I'm just going to buy, I'm not going to lease, don't worry about B or C, just fill in 7A. But if they say, I might lease, I don't know, coming down to Florida, I don't know about here, check off A, B, and C. Put 3% or 5% as it
I
applies.
can fill up all of them in case it's not closing, and then only the ones that you end up doing, that's what will not affect.
That's correct.
So when you say for the lease, we don't practice percentage right now unless it's commercial. We practice half a month. Can
You
we-
do, or 5%, or just,
Let's say the lease is 3,000, can we put 1/5 or 50% of the rent, can we phrase it?
well, right there, it says lease, it says that you can put a flat amount or percentage of
Half.
1 month's rent. So then you would put 50% of 1 month's rent, right? So lease the dollar amount, or you'd put 50% of 1 month's rent. Yeah.
We don't know which one they charge, they want.
What's the difference between the first one and the second one?
lease.
Then again, for the lease,
No,
if,
no, after, in the lease.
right, in the lease, then if there's a broker processing fee for leases, you would put the plus.
I hope they buy and lease because I start to steal this country.
Let's be positive.
Okay. So then we move on to paragraph 8, protection period. Again, this is good for you as realtors. You're protected here. So on the first page, if you have a term of 3 months, nothing happens within 3 months. 3 months and a day, the buyer can't go to the seller and say, hey, I don't have a realtor anymore. I want to have a deal directly with you. They're not allowed to do that. If you leave this blank, it's 30 days. So really now your term is 4 months instead of 3 months.
We can put 90 days again.
Yeah. You could put 1,000 days. But obviously the buyer has to agree to it. So yeah, the longer the period, obviously the better for you. However, one caveat is the last sentence of this agreement says that this protection period expires or ceases if the consumer signs another one of these agreements with another realtor after the term period.
Some will be, and some will say you can buy the property.
So for 3 months, let's say there's a term for 3 months, I haven't signed a contract to buy a property with you. So you have 30 days protection period after that where I can't buy a property without paying you. However, let's say 3 months and 2 days, now I say, okay, I'm done with you. I want to hire someone else. You and I enter into a contract to buy. I don't owe you any money.
As long as they have a different, you cannot go without title, basically.
Correct, exactly. That's the right answer.
You have to honor, if you put 90 days, you have to honor those 90 days, right? And then you can go to another broker.
No,
So if they go to another broker, as long as they sign another one of these, the 90 days ceases. It's no longer applicable.
this protects you not to go into the property owner by himself.
I understand, but if you leave it blank, it's 30 days,
Mhm.
then he's free to go anywhere.
After the 30-day protection period, yes.
But
Okay.
within, no,
But what?
within this 30 days or 60 days or 90 days, they cannot sign.
Directly.
They cannot.
They can sign contract.
They can sign, but they're gonna owe you the commission.
You had 90 days or 30 days that they had to wait.
It's the same
Yeah,
thing, it's
okay.
not exclusive contract, it's the same thing, yeah, nothing different.
That's right.
Yeah.
Mhm. A lot of this language is actually pulled from the listing, exclusive listing agreements, very similar. Next paragraph, 9, conditional termination. So let's say you do have a year term. Buyer says, look, I want to get out, it's not working out. The answer is broker may agree to a conditional termination. So the broker and you do not have to agree. So if they say, hey, it's not working out, I don't want to use you anymore, you can say no, too bad. We have to continue to work together
For the term.
during the term. So if you have a 6-month term and after 1 month they're saying, I want out, you can say no. You can say yes, okay, fine, I don't want to deal with you either, but you can put a cancellation fee here in this paragraph.
It's had, in this previous contract, we had that.
Yeah.
In the listing agreement, there's definitely one, yes.
Yeah.
So whatever that amount is, up to you, completely negotiable. You can put $1 million, you can put $5, whatever you, again, you think the buyer can agree and agree on a price. Maybe, I don't even know what that is, $1,000, something like that for wasting or driving around your time.
How-
They used to do that.
Right, if you do a lot of pre,
Yeah.
so maybe 5,000, 2,500
I would like a 1 month's rent.
Before they sign, okay, so I did.
before they sign, who's
Very
that?
busy, right?
Buyer?
Yes, the buyer or even seller, when I took the listing from her, she says, I'm not gonna put any termination fee. You said, you good? Go ahead.
Mhm.
Finished, we're done. And then we were not finished, she asked me to cancel it after 4.5 months, okay? So I said, I'm not gonna cancel it. We have another couple of months. She contacted my broker and she says, if you're not gonna release my listings, I know the rights, I know what to do. My broker said, let it go. I said, are you kidding me? I spent the $500 just to move here. I had like 8 open houses, so they can refuse
Of course. Yeah.
most of the time.
You technically didn't have legal rights to do so, but then now you're going to litigation. Maybe your broker thought, now I gotta deal with this crazy person. I gotta go to mediation, I gotta hire attorneys. I don't know how it's gonna work out, I don't know anything about it. Your broker was just like, probably just let it go, move on. not a bad decision if you know, our life is about being able to sleep at night and not worrying about people giving bad reviews or telling other people how terrible you are. So again, it's a decision you have to make, yes. So, but if you have it here in this document, then legally they're required to pay you that cancellation fee. And then you can always go to court. So then we go to dispute resolution, paragraph 10. This says that any claims or controversies regarding this agreement first goes to mediation, and then you can go to court. You can go to in front of a judge, unless you check off an initial note. If you initial this section here, so you go from mediation to binding arbitration, where you don't have to hire attorneys and you don't have to pay attorney's fees. So something that you would consider, probably check with your broker how they want to handle this, but it works out this way. Dispute resolution, if this is not initialed, it goes to mediation, then you go to court. If these two sections are initialed, it goes to mediation, then binding arbitration, and then that's it. So I would consider checking or initializing these boxes, avoid you from going to court, and it gets resolved in binding arbitration. And in binding arbitration, the parties split the fees of the arbitrator and everyone shares in the fees. So something to consider. Check with your broker.
Okay.
Paragraph 11 just says you can assign it. No big deal there. Next page. So there are a couple forms regarding this buyer brokerage agreement. This is the transaction broker agreement, which obviously is the default for all agents. I recommend using the transaction broker agreement. Otherwise, if you use the single agent, then you have to do the transition from single agent to transaction brokers, more paperwork. So just use the transaction broker agreement. And this talks about your relationship as transaction broker. You'll deal honestly and fairly, and things like that.
When you talk about transaction broker, representing the buyer,
Yes.
it's just in the check off transact, or we have to write it?
No, this is the form exclusive buyer brokerage agreement for a transaction broker.
It is.
Yes. Yeah. In form simplicity, there'll be others for single agent and non-representation, but use the transaction broker. Just in case you find a seller, I don't know, you find a seller on your own, you can work for both seller and buyer. Okay, 14, this is the big thing that they added from the settlement. It says basically broker commissions are not set by law and are fully negotiable. So that was the whole thing of the lawsuit. They wanted people to be aware that everything was negotiable and not set. And as we talked about that second sentence, broker may not receive compensation more. And the next sentence, however, consumer agrees that broker may receive separate compensation from owner of the property for services rendered to owner by broker. So that means if you represent the seller, you can get 3%. And if you represent the buyer, you can get 3%. Based on the listing agreement, right? So whatever your listing agreement says, the listing agreement is basically going to be the same. There's going to be minor revisions to the listing agreement. Basically, it's going to include language that says the commissions are negotiable. But if the listing agreement says 6% and then 3% to cooperating broker, this paragraph says that you're allowed the 6%.
So basically, no problem.
And that's funny, Max, welcome, and we're done. Yes.
Friend of mine, she had make sign to a buyer.
Oh, let's actually finish with this with Cindy and then,
Okay,
bye, everyone.
I want to thank everyone for joining us today. And if anyone wants to hear about the NAR forms, again, they're on Form Simplicity, or I'll be happy to send them to you. And along with the reasons why buyers should work with the real estate agents, and the seller agents should also work with the buyer agents. So we're happy to assist you, and for any questions or for marketing tips and for your title and closing needs, Florida and Closing and Escrow is here to assist you. You can reach me at 786-457-6832. And if you want to hear about the NAR forms, it is on tape at bowlive.net, so you can listen to the replay. So thank you, everyone, for joining us today.
I'll call you.